Families face a number of challenges these days, particularly when parents decide that they will no longer live together. Whether you are a married couple seeking divorce or domestic partners wishing to go separate ways, this can be a very stressful time for you and your whole family, especially your children. We recently had the opportunity to engage key professionals in the child custody and placement services system on issues that are impacting families. This panel discussion included questions that were submitted by families like you. This video presents the highlights of those questions and our panelists' comments. Let's take a look. Good morning. I'm here today with Court Commissioner Paul Jones, Lindsay Neutral, a family law mediator, and attorney Carol Rogers, who serves as a family law guardian ad litem in Wisconsin. The panel will be answering questions regarding custody and placement issues in Wisconsin. Questions were recorded in advance at various locations or received as email. Our first question comes from Mr. Arthur Smith, and he has a temporary order hearing coming up.
Hi there. I have a hearing scheduled for a temporary order, and my ex and I can't agree on how to split with our kids, Beth and Andrew, and I want a 50-50 split because I want to be a 50% dad. What do I do about that?
Well, Mr. Smith, I will try to answer your question, but I am not sure what a 50% father is. You and your child's mother should talk to each other before you come to court to see if there is actually a dispute between the two of you. To help you have that conversation, I want to make sure that you both understand the terms custody and placement. First of all, custody has nothing to do with the time you spend with your children. Custody refers to the ability to make major decisions about your children. Let's say that Beth has a medical problem and a decision has to be made whether she should have surgery. That would be an example of an important or major issue. Wisconsin law presumes that parents should share joint legal custody. This means that parents are expected to discuss important issues with each other and reach agreements as to how the major issues will be resolved. Some other examples of major issues are what religion the children will be raised in, or whether they attend a public or private school. The exception to this rule includes situations where one parent is not capable of making decisions or does not want an active role in raising the children, and in cases where one parent has been violent with the other or the children. If one parent has sole legal custody, that parent makes the final decision as to the major issue. The parent can still consult with the other parent, but how the important issue is decided is up to the parent with sole legal custody. If either you or your wife is seeking sole legal custody, you will have to convince the court that the presumption of joint legal custody or joint decision-making should not apply in your case. Have the two of you talked about custody? What custody arrangement are you requesting? These are questions you will want to answer before you go into court. Remember, parents may be divorcing each other, but that does not mean that anyone is divorcing the kids. Despite your differences, you both need to keep in mind what is best for your children. You also need to remember that although you are separating, you will still need to cooperate with each other because of the children.
Thank you, Commissioner. Our next question is from Ms. Joanne Link, and I think you may be able to weigh in on this one as well. Ms. Link's question comes from an email. She asks, I have been the primary parent in this relationship. I have done all the appointments, school trips, and stayed home from work for 5 years to take care of them. Why shouldn't I have primary placement?
Before you decide what placement order you want, you need to understand the term physical placement. Under Wisconsin law, physical placement is the right of each parent to have a child spend time with that parent. The law no longer refers to visitation. Both moms and dads have periods of physical placement with the children. There is no standard placement.
When parents can't agree on a placement schedule for their children, they often are required to attend a mediation session with a neutral mediator who attempts to help the parents reach an agreement. We'll now take a question from another parent and allow our mediator to respond. Thanks for being here, Ms. Neutral. Is there anything you'd like to share before we take our next question?
Yes, I'd love to. As a mediator, I'd like to remind all parents that it's important to complete the necessary paperwork, including a parenting plan, if required, before your scheduled meetings, so that you can make the most of the time you have. As part of the preparation, think about the specific placement schedule that will work best for your children. You might be asked to complete a questionnaire or provide other information in advance to your meeting.
Great. Thank you, Ms. Neutral. We'll now take our next question from Jenny Williams.
I was referred to mediation by a family court commissioner. What is a mediator, and what does a mediator actually do?
I'm here to help parents reach an agreement about sharing placement of their children. My job is not to tell parents what arrangement is best for their children. That's going to be your job during the mediation. I will not make any decision. My job is to help parents communicate with one another in a way that I hope will help them to reach an agreement themselves. I ask parents to give me a parenting plan before we meet. It gives me a chance to understand your family a little bit better. From that information you provide, I'll know how old the children are, what work schedule each parent has, and where the children attend school, and other important information about the family that may be relevant to the placement schedule. A family schedule can be important to resolve a placement dispute. For example, I may notice that one parent works part-time and can pick up the kids most days of the week. We could incorporate that placement schedule, or if a parent works 1 week on and 1 week off, we could use that schedule to try and keep the children from spending time in daycare during a parent's scheduled placement. Work schedules often control our availability for our kids. I would also like to remind parents that the purpose of a mediation meeting is not to argue with each other, it's to reach solutions that are in the best interest of the children. One problem I often help parents work through is to get past a parent's idea that a certain percentage of their time with a parent is critical in a placement schedule. Even 50-50 or equal placement can be stressful or disruptive depending on the needs of the child and the situation of the family. Some children handle transitions better than others. One thing to keep in mind is that you can make any placement schedule better for your child by making them feel comfortable as they go from one household to another.
Our next question for our mediator comes from Samantha via email. Samantha asks, I want to have my kids most of the time and have their dad have them every other weekend. He wants to split the time but have me watch the kids on days when he supposedly has placement but he's at work. I just don't think that's fair. In the past, he only watched them on weekends while I worked, and he would just turn on the TV on those days.
Samantha, I understand your feelings. But things are not the same for you, for Dad, or for your kids since you've been separated. Your children need both of you more than ever. The mediation is not about who gets to spend more time with the kids or what is fair for either parent. It's about what is in the best interest for your children. In a mediation session, I would first try and see if we can come up with a plan that lets you both spend quality time with your children.
A mediator is a neutral party, usually a lawyer or a social worker with special training in mediation, who tries to help parents reach agreements about custody and placement. Through mediation, you can resolve many issues, such as where the children will sleep every night, how vacations and holidays will be shared, what activities will the children participate in, or what decisions will each parent make when having placement of the children. Remember, if you and your spouse make these decisions together, then the people who know your children best will be deciding what is in their best interest. If you can't make these decisions, then a judge will have to make them. A judge will take into account all of the evidence presented at the final hearing about what is in the children's best interest and decide on a placement plan. The court order may be different than what either of you is asking for. Remember, you are the experts on your children, so try hard to reach an agreement that is in their best interests.
Samantha, I feel with a little work you could reach an agreement. However, it may take more than one session, or you can decide that this process is not working for you, and you can ask a judge to order an evaluation. If a judge orders an evaluation, a lawyer will often be appointed as a guardian ad litem. This lawyer represents the best interests of the children. The lawyer does not necessarily advocate for what the children may say they want, but for what he or she decides is best for the children based on the information gathered. This is because adults, not children, are responsible for placement decisions. You may also have to pay the guardian ad litem fees, which are typically shared, and any other costs that occur during the custody study. Another family court counselor from my office will conduct an evaluation, along with the guardian ad litem. During the evaluation, you and your friends or family are interviewed, as well as the children's teachers or other people involved in their lives. You may be asked to sign releases of information allowing the counselor access to additional records, such as your medical or mental health records. After the guardian ad litem and the counselor complete the evaluation, they will make a recommendation as to what custody and placement should be. It will no longer be your decision. Then you will have a choice. You can accept the recommendation, or you can have a trial before a judge. That takes a lot more time and can be very expensive. However, the most important thing to remember is that your children will know that the two of you are fighting about them, and you will have a decision forced upon you instead of you making a decision. Finding ways to communicate and problem solve is so much better for your kids than fighting about who gets more time with them. Remember, if the two of you can reach an agreement, there won't be any need for a guardian ad litem or for a custody evaluation.
Our next question is from James Reese, who's concerned about an alternating week schedule.
I just can't handle not seeing the kids for a week at a time like my wife wants to do. I was laid off in January, and I'm a stay-at-home dad. I don't think my wife has a clue what goes into running a house on a day-to-day basis. Laundry, keeping appointments, making sure the kids are off to school on time, packing lunches. There's a million details that goes into running a house, things I do on a day-to-day basis. What can I do?
Well, you haven't really talked about a specific schedule, and there are lots of other alternatives besides alternating weeks. For example, you could start with a schedule that provides you primary placement and gives mom placement 2 evenings during the week and alternate weekends, starting with Friday after school until Sunday evening. It may take a little time to see if mom is comfortable with the responsibilities. Mom can also think about whether she can realistically get the kids to and from school, and the two of you will need to talk about the kids' schedule so that you can share responsibility for their activities. You can do this over the phone, by email, or by a notebook that you transfer when you change placement. Think about what would work best for the two of you.
Your children's placement schedule should be determined by the children's developmental needs, not by the parents' desires. You should consider such things as the children's school hours, whether or not they attend a regular religious service or school, their relationships to friends and other relatives, their attachment to each of you, and how they like to spend their time. It's important to children that they have contact with each parent, but that doesn't necessarily mean seeing each parent every day or even every few days. The goal is to reach a schedule that maximizes the quality of the time that your children spend with each parent. If you and your spouse can't reach an agreement about placement and the judge must decide, he or she will consider the statutory factors in making a decision. We now turn our focus to Ms. Rogers, our guardian ad litem. Will you please explain to our audience exactly what is a guardian ad litem?
Certainly. I'm an attorney appointed by the judge who helps determine what custody and placement arrangement is in the best interest of your children. I will work with the assigned counselor to reach some recommendations about a placement plan as well as custody. Remember, you can reach an agreement yourselves anytime during this process, and I really encourage you to work towards that goal. It is only if you fail to reach an agreement that my recommendations will be made to the judge. So my investigation will be based on the factors that the court will consider.
Here are the factors that the judge will base her decision on if parents can't come to an agreement. Is there a history of violence in the home? If so, the violent parent may have to undergo counseling or take parenting courses before he or she can have unsupervised time with the children. Does either parent have problems with drugs or alcohol? Are there mental health concerns? This could impact on a parent's ability to care for the children. How well do the children get along with each parent? What kinds of activities does each parent do with their children? How has each parent spent time with their children in the past? If your children were asked, what would they tell someone about the things that you do with them? How have the children adjusted to their school, to each parent's home, to the community? What are their relationships like with their siblings? Do they have strong religious ties to a church or temple? And which parent facilitates those activities? If the judge orders a custody evaluation, the guardian ad litem, social worker, or family court counselor may talk with friends, employers, ministers, teachers, and any other knowledgeable person to find out more about the children's adjustment and relationships, and to understand how others view your relationship with your children. Do you have a new relationship that may be causing your children some discomfort? What would others say about how your children are doing in school and in their activities? What are the children's ages, mental and physical health? Are there special needs that one parent addresses more effectively? Just because parents have different parenting styles doesn't mean that one parent is good and the other bad. Remember, both parents have special relationships with their children that the other parent should support, regardless of his or her feelings about the spouse. What are the child care arrangements? Will they have to be changed if one parent has more placement time with the children? The judge also will consider whether the parents can cooperate and communicate effectively about their children. If one parent tries to prevent contact between the children and the other parent, or uses the children to communicate with the other parent, the judge may consider awarding more placement time to the parent who tries to effectively communicate. There may be other questions raised in the evaluation, depending on the particular circumstances of your family. Think about these factors. Answer the questions honestly, and you should be able to see what arrangement will be best for your children.
So, my goal is to make sure the children's needs are met by the placement arrangement, not whether or not it's easiest for you or even what the kids say they want. I try to figure out what is in their best interest and make my recommendations based on that. I work closely with the counselor who will be giving a written report containing their recommendations to the judge.
Well, our next question via email is from Bob Smalley, and Bob writes, "My children seem very upset by my wife and I breaking up. I plan on asking them where they want to live to try to make them feel better. What do you think about that?"
Most children are upset when their parents divorce. One of your jobs as parents is to lessen the amount of sadness, anger, and stress they are experiencing. Some behaviors will make the situation worse for the children. For example, when you argue, raise your voices, or call each other names in front of the children, it hurts them. It makes them feel bad and more stressed out. They often blame themselves for the split, no matter how old they are. Cooperating and reducing conflict with the other parent will help your children adjust. Research indicates that the level of conflict between the two of you is more important to how well the children will adjust to a placement schedule than any other factor. To answer the next part of your question, it would put too much pressure on your children to ask them to pick between their parents. How your children's time is divided between you should be determined by your agreement, or by the judge or commissioner if you can't reach your own agreement. These are decisions to be made by the adults. No one should be pressuring the children to adopt your position. You only make it harder for the children if you try to manipulate them to get them to say what you want to hear.
Well, another email simply asks, how long will this custody study last?
Well, the counselor will submit a report to the court within 90 days. However, 30 additional days are given if there is domestic violence. In rare cases, the counselor may request an extension to obtain more information. I will be at court and will present the evidence that I think is important if we have a trial on placement in the future.
Each county conducts its custody studies in a little different way. In some counties, a social worker conducts the evaluation and submits a report to the court. A guardian ad litem is appointed only if one or both parents disagree with the recommendations made by the social worker. In other counties, the guardian ad litem conducts the evaluation, and if those recommendations are not accepted by the parents, the guardian ad litem presents evidence and testimony to the judge during the trial portion of the case. Check with your county to make sure you understand the process that will be used in your case. Remember, studies show that the time each parent spends with his or her child is far less important than the level of conflict between the parents. Being able to co-parent your children after the divorce or separation is almost always in your children's best interest. Reaching a compromise yourselves is far better than letting the judge decide based upon the limited information that he or she would have, and your agreements regarding your children show that you really care about their best interests. Remember, there are few decisions in life as important as the custody and placement of your children. Make sure that the choices you make are truly based on what is best for them.